instance, when parties are nearing the point of a divorce or custody battle, there is an incident of domestic abuse that occurs between the parties. If the domestic abuse extends to the children, where they either witnessed or were actually a part of the abusive event, the court may restrict parenting time or any contact between the abuser and the children. The effect of this is clear on any custody dispute. If there is a protective order in place barring a party's contact with their children, they will not be able to have contact through the family matter. The provisions of the order for protection will extend to the family law case, and short of the parties agreeing to modify those terms, it will last the full time of the protective order, which is generally 2 years. An order for protection can have additional effects other than just putting a no contact provision in place. In reality, the order for protection may end up resolving some collateral issues outside of just the contact. For example, if both parties were residing together before the abuse, the order for protection may award temporary occupancy of the home to one party, generally the victim of the abuse. This may have a longer-term effect on the other pending legal action if the home is to be awarded in the future. This can have long-term effects on custody as well. The abuser may not be prohibited from having any relationship in the future, but it is difficult to overcome an abusive past to reestablish a relationship with your children. The abuser and children will probably go through some reunification therapy and gradually work to develop a relationship and trust again. If an order for protection only protects one parent from the other, but the children are not involved, there will generally be parenting time awarded. An order for protection does not make it more likely that the court would order sole legal custody, meaning that the custodial parent would have the sole right to make the big decisions in the children's lives. However, there would be parenting time arranged through a third party or through a children's safety center. Obtaining an order for protection gives a party faster results than going through the regular court process, but it should not be abused by parties. Provisions determined in an order for protection hearing may later be modified in the family case that is pending. Also, the court is able to look at all circumstances surrounding the incident of abuse to determine if there really is a valid claim for protection, or if the court believes the party is abusing the system to gain an advantage in the family court proceedings. Parties should not feel discouraged from bringing an order for protection during a custody or divorce proceeding, but it should only be done when there has been a legitimate incident of abuse, or one party is in fear of the other and needs additional protection from the court that they cannot get through the divorce or custody action. The parenting time awarded to parents in abusive relationships varies depending on the unique circumstances of each case. If you have questions about parenting time in your family law case, contact the family law attorneys at Heimrel and Lammers today for a free consultation.